Hi, everyone. My name's Mary Scholl. I am an assistant state's attorney with the McHenry County State's Attorney's Office. I'm here with another assistant state's attorney, Brett Dunbar. And we are both in the juvenile division at the McHenry County State's Attorney's Office. So we are excited to be here today to give you guys this presentation on testifying at termination proceedings. So just a little bit of background on Brett and I. So I have been an assistant state's attorney for about 11 years now with the McHenry County State's Attorney's Office. I started off in the misdemeanor division, kind of worked my way up through traffic court, and then went to felony review division for a couple of years, was in the felony courtrooms, and most recently finished up as a felony first chair, trying all different kinds of felony cases.
Mary, you just muted.
Okay, sorry about that. And so in September of this past year, 2021, I was offered the position as the juvenile supervisor. So I am new to the juvenile division, but I think Brett will echo this as well. But honestly, I feel like this division, we make the biggest difference in people's lives. And I'm sure that as CASA advocates, you feel the same way, that you are really making a difference in these children's lives. And every day I'm at work, I feel like I am doing something that is really important, more so than I ever have in any other position in this office. So Brett and I both are really happy to be in the juvenile division. So I will pass it on to Brett to introduce herself.
Hi, thank you for having us today. I have been in our office for almost 8 years now, and I followed a very similar path as Mary, kind of through a lot of different courtrooms, and most recently I was also a first chair in one of our felony courtrooms, though not for as long as Mary had been, so she's definitely the one with the most expertise. And then I followed her to the juvenile division about a month and a half after she started. So I'm also newer to the abuse and neglect cases. It's a very different world from what Mary and I were used to previously, but I would echo, I think within like my first week, maybe being in the unit, I kept telling Mary, like, I feel like I actually accomplished something when I went home at the end of the day. So we're both very glad to be where we're at. So thank you for having us.
Okay, so I'm going to just kind of jump right into it. Brett, whenever you want to jump in, just go ahead and jump in anything that you want to add. The first question that you might ask as a CASA advocate is, what proceedings will I actually be testifying at? And, technically you could be asked to testify at any proceeding. It is conceivable that the court will want to hear testimony from a CASA if there was some issue that came up earlier in the case. But generally, when you're going to be testifying, it's going to be at a termination of parental rights hearing. For short, we sometimes call that a TPR hearing. And that is usually at the end of the case. It could be as soon as like a year into the case. It could be a couple years after the case has started. So at this point, hopefully as the CASA advocate, you're familiar with the case, you're familiar with the minors, and you have a good handle on what is in the best interests of the children that you've been appointed to. So a termination hearing has two different parts. So the first portion of the hearing we call the fitness portion. Generally speaking, at the fitness portion, we are not going to need testimony from a CASA advocate. At that portion of the hearing, the court needs to find by clear and convincing evidence that the parent is unfit. And it's kind of a bifurcated hearing. So generally the judge is going to set the termination hearing, and he needs to first find clear and convincing evidence that the parent is unfit. If he doesn't, then we do not move on to the second portion of the hearing. Now, once the judge has found that the parent is unfit, we then move on to the best interest portion. And that is where the judge determines by preponderance of the evidence if it is in that child's best interest that their parental rights, that their parents' parental rights be terminated forever. It's conceivable that the court could find a parent unfit, but if there was no foster parent or no person to take that child, or for other reasons, the court could find that it's not in that child's best interest. We, don't see that happen a lot. Usually we're not going to go to termination hearing if we don't know for sure that it's in the child's best interest and we have a foster parent, ready and willing to give permanency to that child. So generally when you come to testify, it is going to be during the best interest portion. Now, you might be asking, how am I going to know when I have to testify? So for all witnesses, we generally will issue a subpoena, and I believe the practice that we have right now is we would forward it to Kelly or Stacy, and then they would forward it to you. I don't know that we've been actually serving people, at their homes or anything like that. And, if I have that wrong, definitely Sherry or Kelly or Stacy, you can jump in and let me know. But
no, that's correct. It comes to our office.
Okay, perfect. And obviously all the CASA advocates are very cooperative, so there's not really a reason to change up that process. And the subpoena is generally going to have more than one day listed on it. That doesn't necessarily mean we are going to need you to testify more than one day. The reason for that is that the court often will set aside several afternoons for a termination hearing because it could take a lot of time. And we don't always know ahead of time exactly when we're going to need you to testify. So we will definitely reach out to you beforehand and be able to narrow down that time frame. If you don't hear from us, please reach out to us or have Kelly or Stacy reach out to us. The thing about court is sometimes things are always changing. We're kind of at the judge's discretion sometimes, his schedule, other things come up. So we will do our best because obviously you all have other places to be and other responsibilities. So we don't want to take up any more time than we need to. But a lot of times, we may not know in advance which day, what time. So if you can kind of just block off those times when you get the subpoena, and then as it gets closer, we'll work with you to make sure we're only bringing you in when we absolutely need you. So beforehand, the assistant state's attorney will reach out to you or send in an email questions that you can prep with. And we may or may not meet in person. We may just talk over the phone ahead of time. I think the last best interest hearing that I had, I emailed the advocate some questions, and then I said, could you please review these? And then can we talk on the phone next week? And then we just talked on the phone and went through the questions. Obviously, if you prefer to meet in person or there's another way you want to do it, we can definitely work with you. So I did kind of go through and just create some sample questions that we might ask you. Now, every case is different. I can't guarantee these would be the exact questions, but this will just kind of give you a general idea of what kinds of questions we would ask at a best interest hearing. So we would start off by asking you just your name, spelling your first and last name for the record. We'll ask you, are you familiar with these minors? How are you familiar with them? When were you first appointed or assigned as the CASA for that minor? Sometimes we have different CASAs within the same case. So I know I've had a case where the CASA said, I was just appointed, within the past 6 months or within the past year. So you'll want to just be familiar with the timeframes that you were assigned to this child. When did you first meet with them? Where did you meet with them? We'll ask you to describe the child, where the child is currently living and like other places they have lived with the family that they're currently with. You know, what does their home look like? Who do they live with? What does their room look like? How many times have you met with them in person? How many times have you spoken with them, you know, over the phone, on Zoom? And it's just generally, you don't need to have an exact number. I know that when you guys prepare your reports, generally you have listed in there every single meeting you've had. So you could go back through your reports and say, you know, I've talked with this child, you know, 50 times on the phone, and I've met with them 20 times in person, you know, whatever it may be. And that just lets the judge know how familiar you are with this child and how much you know about them. This isn't someone you've met once. This isn't someone you've talked to once. And sometimes you may be having more contact than the caseworker even has, because they have so many other cases and you may just have one case. So I think it's really important to be able to highlight to the judge just how much time you've spent with this child. We may ask you, have you had the opportunity to observe whether the child has formed a bond with his caregiver, whether that be foster mom or foster father, or whoever that caregiver may be? We'll ask you to describe that bond. And I think usually the best way to describe that bond is really to give examples of how they're bonding. I mean, the examples are really, you know, endless when it comes to this, because it really depends on the kid. You may notice something like, you know, I noticed that the child likes to read books with their mom every night before bed, and they do that every night. Or, you know, the child really has a strong bond with their dad. They like to, you know, play outside and go on the swings and go to the park together. Or, you know, the child really bonds with foster mom. They both really like art, and that's something that they bond on together. When it comes to younger kids, you know, babies and toddlers, it could be more that the baby or toddler has a really strong bond with the mom. That's who they go to every time they cry, every time they're upset. They immediately go to foster mom and look for hugs. And foster mom is the person who provides them that emotional security. And kind of going into that, sorry, I thought I had missed a slide maybe. You know, we may ask you, have you spoken with the foster parents about how they feel about the child? And, you know, are they willing to provide for this child and provide permanency and love and care for this child as their own? Have you spoke with the minor about who do they want to be with? Who do they call mom and dad? Where do they want to be? Have they expressed that to you? So these are definitely, you know, not limited questions. If there's something that you think is important for us to know. So let's say we send you questions and you're looking through them and you're like, hey, I think it's really important that you know about this. Bring that up to us and we'll incorporate that into our questions. So if there's something that you observe that you think is really important for the court to know, if we think it's relevant to best interest, then we will definitely find a way to bring that up. Okay, a few more questions, sample questions. Do you believe the child feels safe and secure with foster mom or foster father? I think we kind of went through these other ones about if the minor is in distress or has a problem, who do they turn to? Another really good one for the judge is, can you describe a typical day for the minor? So, you know, you can just start from the beginning. You know, they wake up in the morning, they share a room with their sibling, they go and they have breakfast together as a family. Mom helps the child brush their teeth and get dressed. Then they get on the bus. You know, dad helps them get on the bus. After school, you know, mom picks them up from the bus, and kind of just go through a typical day. because for a lot of these kids, you know, they're coming from a home where they don't have any routine. And having that routine for them is so big and so important. And I think that really shows to the judge that this is in the child's best interest because of that routine. The kind of last question that we'll ask you to kind of sum everything up is we'll ask you, you know, based on your observations and your role as the CASA advocate for this minor, do you believe, and in your opinion, is it in the minor's best interest that their parents' rights be terminated? So we will kind of ask you that ultimate question. And obviously, we're going to make sure we know your answer ahead of time. We think we'll know what your answer is if this is the point we got to. But obviously, that's something we'll want to discuss ahead of time if you have any concerns that it's not the right fit. Okay, so the one, I guess, is there any questions from anyone right now at this point? Or Brett, do you have anything that you wanted to add in?
I was just going to echo what you said about letting us know if there's anything that we need to add when we're prepping with you or when we send you questions, because I mean, truthfully, you know a whole lot more about the minor and where the minor is situated than we do, because all we have is, you know, the reports that we've received from you. Sorry, my phone just started ringing. The reports we've received from you, the reports we've received from the agency, you know, as we're preparing for the hearing, we may have had a conversation with the foster parent, but a lot of times we don't even know who the foster family is until we get to this proceeding, and we have to find out who they are to get them to come in. So I just want to echo that, you know, as you're going through it, if you think that there is something that we should know about, tell us, because you're the experts when it comes to this minor and what is in the best interest of the minor, not us. We don't have as much information as you do.
So we do have one question. As CASAs, we try very hard to be very objective, and maybe some of these questions ask a little bit less about our objectivity. Can you talk to how objective a CASA should be, especially regarding that very last question about what we believe is in the child's best interest?
Yes, so I do think that generally speaking, obviously a CASA should be objective when they're observing the minor and when they're preparing their reports for the court. But I do believe at the best interest portion that would be a time when the CASA's opinion could matter for that final question. Because the best interest really is sort of a it could be partially subjective. So I do think at every other aspect of your job, every time you're writing a report and when you're providing information to the court, definitely you're the eyes and the ears of the court. So you are providing the facts and what you observe. But I do think that final question, if you guys are comfortable answering that, if you're not comfortable answering that, or, you know, Sherry and Stacy, if you guys don't think that that is their role to say that, we won't ask that question, and we can ask the caseworker that question or the foster parent that question. But I do think that your opinion, ultimate opinion on it, that the judge would take that into consideration.
I would also say, you know, because we'll go over this with you beforehand, don't worry if your answer is no. You know, we're not, Mary and I aren't asking you to only give us the answers that you know, you think we want to hear. So you are allowed to remain objective in that regard, right? If you're taking an opinion that's different, and frankly, we probably wouldn't ask you that question if we prepped with you and that was the answer that you gave us, but it's okay to be honest with us about where things are at, because like we've already mentioned, you're better situated than we are. So I don't know if that kind of plays to the objectivity a little bit too, in the sense that yes, it's subjective and you're taking an opinion, but your opinion doesn't have to be the same as us necessarily. 99% of the time, I'm guessing it will be. If we've gotten to the point of reaching a termination hearing, there's going to be good reason for that, and we probably will be on the same page. But I would just throw that in there too, that, you know, we're not asking you to give us what we want to hear. We're asking you to give us the truth.
Okay, so hopefully that kind of helps answer that question. And, you know, one thing that anytime I speak with a witness, whether it's in a juvenile abuse case or in a criminal case, their number one question is, what's going to happen on cross-examination? What am I going to be asked on cross-examination? Everyone is worried about cross-examination because it can be kind of unpredictable. And the truth is, we don't always know what the respondent parents' attorneys are going to ask you on cross-examination. But there's really only like some simple guidelines. I mean, the number one rule is you just have to tell the truth. So if they ask you a question, the best policy is you just give them the answer. If they ask you about something that you don't know and they ask you a question that you don't know the answer to, because it's either an area that you're not familiar with or something you don't know about the child, it's okay to say, you know, I don't know, or I don't recall. As long as you're familiar with, you know, your previous reports and you're familiar with the child, especially at this point in the hearing, it's not really going to be, I haven't seen like a real intense cross-examination at the best interest portion. It's possible that it could get more intense depending on the type of case. But again, you know, you don't need to argue with the attorney. The only thing you have to do is answer their question and answer it truthfully. Do not worry about hurting the case based on your response. So like if they ask you a question and you're like, oh no, I'm worried this answer is going to hurt the case, do not worry about that. All you have to do is answer the question, because the state's attorney afterwards has the opportunity to redirect, which means we can ask a follow-up question. So if they asked you something, but it seems like there's more to it, we'll be able to ask you about that afterwards. Let's see if I have any more. Oh, this goes to cross-examination and to any time you're testifying. So let's say, for example, on cross-examination, a respondent parent's attorney asks you, you know, on such and such a date, isn't it true that this happened or the child did this? And you're thinking, I have no idea what he's talking about. I can't remember what happened on that date, but I know I wrote a report about it. And if I looked at my report, it would refresh my memory about what happened. So this goes for both whether the respondent parent's attorney is asking you a question, the GAL is asking you a question, or the state's attorney is asking you a question. If we ask you a question and you don't remember it, you can say, you know, my memory has been exhausted. And what that's going to do is that's going to cue us to ask you, is there anything that would refresh your memory? Now, if you say, yes, my notes would refresh my memory, or any other thing that you want to look at, you are permitted to look at anything to refresh your memory on a question that's asked. Now, obviously, if we ask you something and you know there's nowhere in your notes, you just don't remember it, you can just say, I don't remember. But if we ask you if there's anything that would refresh your memory and you say yes, we will show you your notes. So if you want to bring your notes with or any of your prior CASA reports, you can look at those. Now, hopefully this situation won't happen because we're going to prep with you ahead of time. You're going to know the questions we're going to ask you and you're going to be ready to go. But if you do find yourself in a situation where you're saying, hey, I don't want to give the wrong answer, but I just can't remember this, it's okay to ask to look at your notes. Now, one of the rules about refreshing recollection, though, is that you cannot read off of your notes. So we're going to give you your notes, okay? You can look at them. Then we're going to say, okay, has your memory been refreshed? If you say yes, we take your notes away. We'll ask you the question again, and then you can testify. I know it sounds kind of weird. You're probably thinking, why can't I just read from my notes? But the rules of evidence do not allow that, and the judge is not going to allow that. You can take as much time as you need to review any notes, and you can look at anything. If you say, you know, you need to look at a note on your phone, or you need to look at some other note that's not a report. Let's say you just prepared notes ahead of time for yourself. Totally fine to look at that. Refreshing recollection, though, is kind of a last resort. You don't want to be refreshing your recollection on everything. We don't want to be asking you, okay, what is the minor's last name? And you're going, oh, I can't remember. I got to refresh my memory. Or what's that minor's date of birth? Or where's their placement? Who do they live with? It's not going to look good if you have to keep looking at your notes, because then the judge is going to think, well, does this CASA really know this child if they don't know these kind of basic things? So those are things that you would want to memorize ahead of time. And I don't see this as being an issue at all. But it's just something to know for testifying. And this is advice I give to anyone who's testifying. This isn't just limited to CASAs testifying in court. So I kind of already touched on this, but, you know, just be prepared, review all your notes ahead of time, think about your answers to the questions. Just a little bit about the court proceedings themselves. So when you come to testify, it's possible that you may have to wait in court. So we probably have multiple witnesses testifying that day. So when we say, like, we need you there at 1 o'clock, proceedings, like, we will be in court until 4:30 generally that day. It is possible that you would have to stay there for several hours to testify. Now, as much as possible, we will try to predict, okay, don't come at 1, come at 2, you're going to be our second witness. But sometimes we can't always predict how it's going to play out. So it's possible that you get there and that the judge has an emergency hearing and we get bumped to later. So, you know, when you see 1 o'clock on the subpoena, don't be thinking, oh, I'm testifying at 1, I'll be out of there by 1:30. That's not always the case. And if you have any questions, if you have any conflicts, like if you're like, I have to pick up my daughter at 3 o'clock, or I've got something really important, let us know that ahead of time, because we will make the arrangements to schedule ahead of time and let the judge know, you know, we absolutely, the CASA cannot be here on this day to testify. These are the times they're available. And we will try to work with you for that. You know, ultimately it's kind of the judge's call, but he's flexible on that sort of stuff. So that's just something to keep in mind. After you testify, anytime a witness testifies in court, there's going to be a motion to exclude witnesses. And what that means is that you cannot discuss your testimony with anyone while the proceedings are still going on. So you can't talk to the foster parents about your testimony. You can't talk to the child about your testimony. You can't talk to DCFS about your testimony. You can't talk to anybody about your testimony. It is a completely closed proceeding, but there's also something called a motion to exclude witnesses, which means you can't discuss your testimony with anybody else. We may tell you you're free to leave for the day, but even once you leave, you can't discuss your testimony until the proceedings are completely over. Once the proceedings are over, then, you know, you could talk to, you know, like the caseworker or foster parent about what happened in court. But obviously juvenile proceedings in general are closed to the public. So it's not something you can talk to someone who's not part of the proceedings with.
On that note too, Mary, with the motion to exclude, it also means that you cannot be present in court for other people testifying. So you won't be able to sit through the entire proceeding. You're only allowed to come into court during your portion of testimony.
Yeah, that's a good point. Thanks for bringing that up, Brett. I forgot about that part. So I don't see this as being an issue at all, but sometimes witnesses will ask us, you know, what should I wear to court? Usually what we tell witnesses is, you know, dress in business casual. You could wear a suit. You don't have to wear a suit. Something you would wear to a job interview. Okay. So, you know, not that you could still wear jeans. Jeans are not a problem as long as you're dressed, nicely, a nice pair of jeans. You don't want to come in with like ripped jeans and a t-shirt on. It doesn't look professional to the judge. And, just keep that in mind when you're coming into court. Obviously, like the past couple of years, like not a lot of people have been coming into court. We're just appearing via Zoom. So when you appear via Zoom, you can kind of just be in your pajamas and that's okay. But now with coming into court and testifying, just keep in mind, you've got to be dressed appropriately for court. I don't see this as an issue at all, but just in case anybody's wondering what you should wear in court. When you testify, it's very important that you speak slowly, clearly, and loud enough for everyone to hear. This is especially important because in our courtroom, there is no court reporter. Everything is recorded though. The entire proceeding is being recorded, and every single termination proceeding, the parents have an automatic right of appeal. So what that means is that after the termination proceedings, if the judge terminates parental rights, a court reporter is going to go back and listen to the entire hearing and take down every single word that every witness said. So if you're mumbling on the stand or not talking loud enough, the court reporter is not going to know what you said, and the record's going to be silent, and they're not going to have anything in there, and it's not going to make the record. And that could be important later for an appeal. It's really important that everything that's testified to is on the record. So that's why it's just really important, even though you don't see a court reporter there taking everything down, at some point a court reporter will be taking everything down. So I don't have anything else prepared. That kind of covers everything that we had, but I did want to open it up for any questions that you may have on testifying or any other topics having to do with court.
Mary and Brett, I just wanted to
Yeah.
tell you that this was very clear, so thank you very much.
Sure. Yeah, I hope it was helpful. Obviously, if you have any questions, I have our contact information here. And, we really appreciate the CASA reports coming in so timely. A lot of times we don't get the caseworkers reports until, the night before, or sometimes not at all. And then we really rely on the CASA report to kind of figure out what's going on. And so we just really appreciate everything you guys do. And we know it takes a lot of time. Like it's very clear that you spend a lot of time with the kids and put a lot of time into your reports, and we do appreciate that.
You. That's helpful to know because we know it goes into a black hole when we just send it off for you guys. I wrote down a couple questions that might come
Sure.
up, and if anybody else wants to chime in, please feel free, or you can put them in chat and I'll take care of that for you. So you started off indicating that people were subpoenaed for specific days. And what I'm wondering, I've seen it in the past where things have changed, the dates have changed. Are those subpoenas still good, or do you have to re-subpoena our CASAs?
So often what the judge will do if it gets continued is he will enter an order continuing the subpoenas. So if he does that, then the subpoena is still good pursuant to that court order. But if you ever need a new subpoena, we can prepare those and send a new subpoena for the new dates, if it makes it easier just to keep track of what dates.
Oh, that's good. I would imagine, like if people needed it for work or something, we could also provide them with perhaps the court order or something that shows that it was continued. So unless somebody specific has an issue about their subpoena, the way it's going works for us.
Yeah, just let us know. That happens a lot actually with our officers where they need us to issue a new notice to them as well, just for work purposes so that they have a record of it. So if you need a new one with the new date, just let us know. We can get you a new one pretty easily.
Excellent. Do you ever subpoena previous CASAs who are no longer the active CASA on the case?
Depending on the circumstances, we may need to. I guess it would depend under what circumstances they left and whether their interaction with the minor would be relevant to determining the best interests. It's conceivable, but usually if the current CASA has been with the kids long enough and is able to answer those questions, then I don't know that we would call in the previous.
Okay. Good. And I know the court proceedings are closed. Typically, a CASA attends court with a CASA manager. Does that person come with them? Or is that person excluded from the proceedings? How does that work?
So the CASA manager would be able to sit in when the CASA advocate is testifying, but I don't know that the judge would let the CASA manager sit in for the rest of the proceedings because of that motion to exclude witnesses. But that would be up to the judge probably.
I was going to say that's
Yeah.
probably going to be the judge's call, and we would just have to ask, and he might even ask the parties what their position is, because if that CASA manager is not testifying, technically the motion to exclude doesn't necessarily apply to them, but then you're dealing with the confidential nature of the proceedings, but CASA can usually sit in on it. So I that's not something that Mary and I are probably going to be able to control. It would just have to be a question for the judge. But even if they can't sit in for the entire proceeding, they can still come.
Okay, very good. How often do cases move to a TPR situation, say annually? About how many do you cover?
I would say probably maybe 10% of the cases would actually go to hearing.
Okay. Which judge hears a TPR?
So Judge Harmon is the juvenile court judge, and he would hear the termination of parental rights hearing. We do have a handful of cases that have been assigned to other judges because Judge Harmon either has a conflict based on his previous employment, or there could be other reasons for him to transfer it to another judge. So it's possible that another judge would hear it, but Judge Harmon is generally going to be the judge hearing those types of hearings.
Well, and if it's a different judge, the case will have already been in front of that different judge for a period of time. So the CASA advocate should already be aware of that change too.
I think the question might have more to do with the different judge here TPR than the judge that's had the case all along.
No.
Okay. Who initiates the TPR proceedings?
So the state generally files the termination petition. Technically, the GAL could file it as well, or DCFS, but in our county, the general practice is that the state's attorney would file the termination of parental rights. And there are several bases under which we can file a termination of parental rights, but generally the time we're going to do it is when we have at least a 9-month period from the disposition or adjudicatory hearing where mom and dad are not making reasonable progress nor reasonable efforts. So sometimes it's hard for us. The reason that sometimes, we may think that we are getting to a termination, but if the court is finding reasonable efforts or progress on mom and dad, we're not going to be successful at termination hearing. So sometimes we need that finding before we can file the petition.
Also, isn't the legal screening part, there's a portion of where the case would go to DCFS legal screening so that you know as a state attorney that there's enough information to be able to file that TPR, is that correct?
So the legal screening is another process that we likely want to have done before the state files their termination petition, because if we move to terminate, but legal screening doesn't pass, let's say because that child has no placement, then that would be a situation where we may have an unfit parent and we may be able to prove that. But when we get to best interest portion, the judge is going to say right now, it's not in the best interest to terminate this child's parental rights because we don't have permanency for this child. So we need to make sure everything's aligned. It's past legal screening. We have the proper basis to terminate. Then we're going to move to termination hearing. So yes, definitely, Stacy, the legal screening is another thing that we're going to look for before we file a termination petition. We don't have to have it to file it. Like maybe it's sent to legal screening and we get our termination petition on file. We can kind of do those simultaneously, but we definitely want to make sure DCFS is, has the same position as us and is on the same page, because if the GAL and DCFS aren't on the same page as the state, it's not going to probably go well for us. We want to all be on the same page. So when we go to hearing, we're successful.
Well, and when the judge is the one suggesting to send it to legal screening, which happens on a lot of these cases, it's a good tip off to all of the parties that we're heading towards a potential termination, which sometimes, works in the state's favor in the sense that then, maybe the attorneys start having serious conversations with the respondent parents about what's the appropriate next move for them before we actually get to a termination hearing.
How often does a TPR hearing begin, and then the parents choose to surrender instead?
I haven't seen that happen yet where we've actually started the hearing and then they've chose to surrender, but I have had where we have a hearing set and literally on the eve of the hearing, they decide to sign surrenders.
You mentioned that automatically parents have it's auto appealed. Can you talk about that? I know when we've as a group talked with Judge Harmon, he's talked about wanting to make sure that things aren't appealed. So I just want to kind of clarify that.
So they have the parents have an automatic right of appeal. And I think probably what Judge Harmon was saying is that he wants to make sure that it doesn't end up getting like overturned on appeal, I think is what he means to say. So like if everything isn't in the record, the appellate court could overturn, the judge could terminate parental rights, but if they find an error in the record, they could overturn it. So that's why like I was talking about, like making sure in court, everything is very clear, because a court reporter is going to go back, type out everything that happened at every hearing, and then an appellate court is going to review the transcripts from every proceeding and determine whether it should be overturned.
That's also why you probably sometimes are sitting in court and you're seeing us do things that seem unnecessary, or why are we getting another court date to deal with this when it's been an issue? A lot of times it's because we are trying to preserve the record and make sure that everything is happening properly so that when we get to the ultimate end, it's not going to be an issue down the road. I know sometimes people get frustrated in any court case, how long it takes, or how, when you're not in it every single day, some of what we do doesn't always make sense. So if you have questions, just let us know and we'll try to help you figure it out.
I have a question because I I've been doing this for a long time too, but so I'm a little confused on so if it goes through termination and the judge terminates the parental rights, the parents have the right to appeal, but it doesn't mean that every case is appealed, right? They just have the 30 days to appeal the decision, but not every case gets appealed.
True, they have the automatic right of appeal. So like on a
Okay.
criminal case, like you don't always, like depending on the case, like you have to have a basis to appeal. But in a termination proceeding, it's an automatic right of appeal.
Okay, but not everyone chooses that to appeal it.
If they appeal, do they keep their court-appointed legal representation, or is that something the parent needs to pursue on their own?
You know, I am not sure of that. A different office handles the appeals. We do not handle the appeals. But I think the appellate defender probably gets appointed for the parents, and the Illinois appellate state's attorney's office handles the appeals. We do not handle those.
Along those lines, if the parents do give up their rights, do they ever have the right to appeal again if it's prior to the end of the case?
Do you mean if they sign surrenders?
Yes.
So as long as the surrenders, I mean, I don't know all the ins and outs of that area of law. Like we would not really get involved with that. But my understanding is if you sign surrenders, I mean, the surrender paperwork, it is like a stack of paper, and the judge sits down with you and goes through it with you, and you are signing away your rights as parents forever. And unless they find that there was some sort of coercion, or that you did not understand or were not of sound mind when you signed that, that is binding and irreversible without, and some sort of, they'd have to find that there was some sort of coercion or something.
Thank you.
Mary and I aren't actually allowed to be present when parents are signing surrenders. So it's a little bit foreign to us too. We don't sit in there and hear all of the admonishments and hear everything that the judge says to the parents as they're signing the documents. Because he wants it's a difficult emotional thing. So Judge Harmon is just there with the parent and their attorney, and we're not allowed to be present for it.
What if a parent does not appear for the TPR hearing or can't be subpoenaed because you can't find them?
The hearing just proceeds without them, and it's just another strike against them.
Okay. All right, CASAs, last call for questions. Give everybody that last minute to type and press enter. Well, Brett and Mary, thank you so much for being with us. This has been so informative. It's a black hole for many of us because, like you said, it's 10%. It's not something we do often. And we do so support return home. So, this is a hard end for many folks. I am getting so many thank yous from all of our CASAs in the chat. So it is just appreciated. CASAs, don't forget to give yourself some CE credit for juvenile court, and we will get those approved. Thank you, everyone. Have a great afternoon.
Thank you.
Thank you for having us.